Welcome to Legalese. I'm attorney Christopher Lilly. I'm your host. We're joined today by Sheila Harrington, who is an attorney as well as a state rep from the Groton area. Yeah. Your area as a state rep covers Groton, Dunstable, Harvard?
Not Harvard, actually. It's the first Middlesex, so it's Groton, Dunstable, Pepperell, Townsend, Ashby, part of Ayr, and part of Devon.
Thank you, Sheila.
I'm used to saying it.
Thank you. I'm glad you said it. But Sheila is joining us today on a very special topic, which is criminal justice reform. In April of 2018, Governor Baker signed into law the Criminal Justice Reform Act, and that was something that Sheila had worked on quite a bit in her role as state rep, having served on the Judiciary Committee.
Yes.
And from that, we have some sweeping changes that have occurred and are now have come into law, and we're going to talk about that. But let's start with talking about your experience with the Judiciary Committee and how this law came out of that.
Okay, great. So actually, I have served on the Judiciary Committee for 8 years. Most of them, I think at least 6 of them, I have been the ranking member on the Judiciary Committee. So the ranking member would be the highest minority member, and then there's a Senate chair and a House chair and a Senate vice chair and a Senate and House vice chairs. Okay. So essentially, out of the bills that are normally filed every session, there's approximately 5,000 bills every single session. There's about 27 committees, I think. But 1,000 of those bills go to the Judiciary Committee, and the other 4,000 are split among the other committees. Okay. So we definitely have the lion's share of bills to review, and we cover major areas like probate and family law, criminal justice, criminal procedure, estates, guardianships, motor vehicle laws, personal injury laws, constitutional issues. So we really have a pretty wide scope. Over the last 8 years, though, we have had many hearings on criminal justice types of issues and many different forms of bills, both from the House and the Senate, addressing issues like mandatory minimums for drug offenses, abuse of solitary confinement, juvenile issues, diversion program issues, restorative justice issues. So all sorts of things. So what we did this past year is we put together, the House did and the Senate did, we're a joint committee, but we put out 2 separate bills. So what happens is when the 2 chambers have a similar bill, meaning we both did criminal justice reform in what they call an omnibus fashion, but our bills were significantly different in what we wanted. If they pass, the Senate passes their version and the House passes their version, then it becomes necessary for them to appoint a conference committee to come out with a consolidated bill that they can both live with. And
is that when you came in with this, with your role in the committee?
Right. So, well, not so much on the, I already was involved in the beginning of it with the Judiciary Committee, but then they pick 3 members of the House are appointed, and 3 members of the Senate are then appointed to work together and have what they call conference committee meetings until they can come up with a compromise or a consolidation. So we started working on the conference committee probably late November, early December, and we met up to maybe 3 times a week, you know, some weeks only once or twice, for many months, and we finally came up with an agreement in March of 2018. And it was signed, it was voted by both chambers and signed into law by the governor in April.
And so when you were in this conference committee and prior to that in the Judiciary Committee, what were some of the issues that you were looking at that became part of this act?
Right. Well, I would say one of the biggest issues that we had been looking at were, well, a couple of them. One would have been mandatory minimums, especially with regard to drug offenses, how they have come to play over the years. And diversion programs was a big one, and the solitary confinement issues had become really a forefront issue as far as I was concerned. And I think what happens is, so the Judiciary Committee has hearings on every single bill. And people from all over the Commonwealth and sometimes from out of state will come and testify. And there was a lot of very compelling testimony in all of those three or four areas that sort of led us to some major changes. There was also a sense that we wanted to make sure that justice had nothing to do with your economic position in life. So there was a lot of scaling back on you being incarcerated if you couldn't come up with money, because that tended to have to hit certain demographics more so than others. You know, there seemed to be a racial imbalance as far as pre-trial jail time because you couldn't come up with bail. And there also seemed to be sort of an issue with some people being held that it was really an issue of like an addiction issue or something like that, where we could maybe divert them into a help program that may ultimately get them out of it and we wouldn't need to put them in jail. So we took a long look at those items especially. But I think given the opioid crisis, I would have to say that the drug issues and the mandatory minimums were a huge piece. That was really the first piece we attacked, and we had to keep tabling it and coming back to it because we couldn't seem to come to resolution on it for quite some time.
Now, in reviewing the Act and how things had come about, it does appear that there's it's fairly well balanced in terms of some of the leniency that's given on the one end, but some of the more harsher punishments that you might see on the other. Let's start with diversion, though.
Okay.
And what are we looking at? What has currently existed, and how have you addressed it?
Well, diversion programs and restorative justice programs, both, have been not used to the fullest. They also have been very much categorized when they are used to just juvenile situations. So we've extended the diversion programs so that adults are able to get them as well. In addition, we started an exploratory commission that is going to be looking into issues with regards to kind of a new trend in criminal justice, which is looking at who they call emerging adults as a different category. So the belief being that if we divert them, that we create programs that are different for people between the age of, say, 18 and 24, instead of just locking them up with the general population, we may be able to prevent recidivism down the road. And some of these diversion programs would include career-type training, skill building and things like that. And in fact, some of us were actually, and I was among a delegation from Massachusetts that went to Germany actually at the end of March to look at some of their emerging adult justice programs, as they've become well known for it in Germany. And there were parts we would take from it, but there were parts we probably wouldn't. I think we have better programs sometimes in our youth services, Department of Youth Services, and we're trying out things. For instance, Sheriff Katusian, who's here in Middlesex County in Billerica, is doing a pilot program with setting up a new program for emerging adults. But the idea was, especially when you have issues of drug-related or alcohol-related, maybe we can get them into some kind of help program, and it doesn't really matter what their age is. And also with restorative justice, which would deal more with property-type claims, that kind of, damaging someone's property or doing something to somebody. The restorative justice program sort of brings the parties together, and I think you probably know as an attorney that and it could be violent acts, I believe, as well. But
I think there was a simple assault and battery. One of them was covered.
You could have that too. And I think what people don't realize, and I think lawyers in the field do, that even if somebody gets convicted for an assault and battery, the victim and his family, they don't always feel great about it.
Sure.
It doesn't settle anything. So part of the restorative justice programs is that it's going to give more people an opportunity to do face-to-face with the help of a sort of a facilitator, mediator type of person. And they end up apologizing, and they end up doing something to make up for what they did. And, you know, we heard incredible testimony on those programs that have been tried out in different areas where people have actually gone to work for the person that they harmed. That person
really?
has helped them go through college. Like, you see these incredible life stories of people that could have gone through the rest of their life. The kid could have gone on the wrong track. The person would have probably become very bitter about it. But because they actually sat face to face and the victim got to tell the aggressor what they really did to them.
Right.
And they apologize and they understand the wrong, and it doesn't happen again.
Now, we had a nice episode of restorative justice, I want to say a couple of years ago that really went into a lot of that, and I think it sounds good that now we're bringing that
Now
to
it's
the forefront
incorporated in our program.
into the mainstream. And it's not just for the victims, but also for the person who finds himself in trouble.
Right.
Theoretically, for the first time before the criminal justice
Their
system.
life isn't ruined.
And it's a way of diverting them from the district courts.
Right.
And from my perspective as a defense attorney, that's something that you really
And along that lines, we also created more expungement type of thing, easier ways to get certain things expunged, because a mistake somebody makes when they're 18 can follow them in their career for years and years to come.
Sure.
And so we've tried to create ways that mistakes that are made, if they're not repeated mistakes and you don't learn from them, but you actually learn from them, down the road, we can take that off your record and make it easier for you to be able to get a job and to really be able to enjoy your life at some point. So those are important. The drug thing now, we're faced with, part of what we are faced with is that the newer narcotics that we're seeing, there was a sense of urgency in this bill, especially from law enforcement, because we did not, at this point, properly have scheduled drugs like fentanyl and carfentanil, which are presently wreaking havoc. So, as you said, we balanced it quite a bit on the drugs, but what we had to do is really look at what is trafficking and how trafficking differs from using.
Sure. So I think it sounds like drugs really stretched across a lot of aspects of this, not just on the diversion end, but now we're starting to move into, I think, a mandatory minimum discussion.
Right, right.
And we're talking about fentanyl, which has become a terrible bane on society.
And we didn't have
it
classified in a way that law enforcement could really kind of take care of people that were trafficking it. And you know, a lot of people have this notion that people that are dealers or traffickers are just trying to support their habits. But that isn't actually the case. There's a lot of heavy hitters that aren't users, but they're good businessmen. And what I think sort of came through all the testimony we've heard and all the information we were able to receive on this is that they're in the business of trafficking this, and it's really a business of trafficking death, especially with carfentanil. And I think you and I were talking outside. One of the most kind of compelling statements I've heard on carfentanil, I heard it on the radio one night coming back from the State House, but it was the governor of New Hampshire. And when he was trying to describe the devastation of carfentanil, he said that if you took one of those Morton salt containers, and each grain of that was carfentanil, there's enough in one container to kill everyone in New Hampshire and Vermont combined. One container. Wow. So the amounts that you have are so tiny that if you figure a grain of salt is all you need, it's very, very hard for law enforcement to chase this. And our technology that we have in the Commonwealth doesn't have the ability to sort of grade amounts either. So basically, if somebody has cocaine, which is one of the big avenues to fentanyl and carfentanil. They're lacing cocaine with fentanyl and carfentanil. In fact, our cocaine importing into Massachusetts, we believe, is somewhere like 60% higher this year than prior years. Wow. Because cocaine is so necessary to the fentanyl, carfentanil business. And we can't measure how much of it is fentanyl or carfentanil. We don't have that ability. So if there's any in it, we've now decided any is enough. If you're trafficking fentanyl through cocaine, we're not going to look at how much fentanyl you have in it. If you have fentanyl in it, we're going to give you the fentanyl penalties. Now,
isn't fentanyl also what's being attributed to a lot of these heroin overdoses? Yeah. And a lot of it is the fact that the heroin is either laced with or replaced with fentanyl, right, such that people are now overdosing. Right. And that's what's causing such an epidemic.
Right. And that's partially why there's been several bills. There's one called Stevens' bill that came before us, which was a heart-wrenching day of testimony with people that testified, but they were all someone who had lost a loved one because somebody had laced heroin with fentanyl or carfentanil. And they wanted it to be sort of changed that if you're the one who provided it to them, whether it was at a party or you're a dealer, you'd be charged with homicide, which is hard because we don't always know whether the one who provides it to you has the knowledge. Yeah, so it was a tough bill to, we weren't able to really incorporate, as much as our hearts were like bleeding for these people, we really couldn't find a way to legally and constitutionally put that into our criminal laws. But the interesting part about that was almost every single one of these families that testified, their family member had been in recovery. And they seemed to be doing well. And the one slip up that they apparently had, and I guess the difference is it's not like you need more, you can have a very tiny amount if you're in recovery from these opioids, and that can kill you. Like, if you had been continually using, it may not have, but if you've been in recovery for a while and then you take them, you die like that. And so
because you come back to where you were, but you're still used to taking what you were taking.
Yeah, and it just kills you right away. Yeah, it's really, so those were the hard things, and there was some definite give and take.
So how did the mandatory minimums come out and all of this, and what?
Well, we took out some mandatory minimums, and some of them were obvious. You know, they're not as big of an issue. And in exchange for taking them off, sort of the lower drugs or changing the parameters of how much you could have, some things we weren't willing to do. The Senate, for instance, had proposed changing it, I think, from 15 grams of cocaine to be considered a trafficker to 100 grams. And the House members were just not, you know, they weren't going to agree to that. So we didn't want to open up the door for worse cocaine use, especially where people are lacing cocaine with fentanyl and carfentanil. But what the biggest difference is, it took away really mandatory minimums for possession type cases, for users. It really is designed now with
low-level distributors.
Yeah, for low level. It's now designed to really go after traffickers and high-level dealers. And incidentally, when one of the members of the conference committee would bring in her local newspaper articles every meeting, and there was a strong correlation between unlawful gun possession and trafficking.
Oh, yeah?
That we found that, so that it, you know, it looks like it's a drug issue, but a drug issue can turn into a violence issue, a homicide issue. It can be a gang-related issue. It can be, so it's like from that opioid issue especially, you're branching out into other dangerous territories. But this person would bring it in, and everybody who was arrested for trafficking was also charged with like unlawful weaponry too.
That was part of a study that you did?
Well, no, this was just in the Brockton area newspapers.
Okay.
But we were like thinking about
anecdotal evidence.
No, so it was like not an authentic study, but it was interesting to see that it's not an isolated issue.
Sure,
you know, that when you have trafficking of drugs, you probably also have weapon misuse, so to speak, and gang activity potentially too. So that was a big part. The solitary confinement, as I said, that was one that really haunted me a lot.
What was the issue? What were you trying to address there?
The issue was how long someone can be in solitary confinement.
Okay.
And the problem was that we didn't really have very strong parameters in our house of correction as far as somebody staying in it.
Okay.
And the evidence really shows that your mental deterioration can start very quickly in solitary confinement. But we had some people that were there for months and months and months. And what was happening is these people were getting out of prison from solitary and not able to assimilate into society again.
Because of that experience?
Because of the mental sort of mental deprivation or whatever of socialization over time. They start to become very fragile mentally and emotionally, and a lot of suicides post-conviction. And the other part about it is solitary confinement is not anything that the courts have anything to do with. So no one gets sentenced to solitary confinement. It's totally up to the staff in the prisons.
Right.
And it varies from sheriff to sheriff. And so what we tried to do is create sort of a
some parameters.
And with the thought that you can't be there till the day you leave a sentence. You have to assimilate back into normalcy, and there's got to be checks and balances as to why you're continuing to stay there.
Okay.
And reviews of whether you should still be there and things like that, so that we don't have, maybe in one prison it's not an issue, or, it's only used for people that are a threat to their own safety or other people and only an appropriate amount of time. And then maybe others saying that they're spending years in it, So it really varies.
Have there been studies done that you looked at that showed what is appropriate versus what is abusive?
Right. We also, in fact, one of the conference committee members actually went up to Maine, who actually have done away with solitary confinement, and to learn more about the effects of taking it out of their penal system, and taking it out altogether, and they seem to be okay with it. We're not, I don't think we're there yet in Massachusetts, because we tried to also listen to all the different players, the sheriffs, the district attorneys, and sometimes something that sounded like a good idea, if you started talking to certain law enforcement people, they're like, oh, don't go there, because this is what's going to happen. And sometimes you wouldn't have thought of the unintended consequences of certain laws. Like, one of the things we did not put in, and there had been a lot of testimony on the Romeo and Juliet bills, they call them. And it's those ones where a youth boyfriend-girlfriend situation occur, and one of them's underage, and then one of the parents chooses to wants the older person who's over 17 prosecuted and whatnot. What the district attorneys told us is we won't prosecute those cases. When we learn the facts that there's like an ongoing relationship, and we believe from our investigation that it was to some extent consensual, we don't prosecute it. But if you make parameters, parents will insist we do. So there was proposals that you said, like, if the aggressor is perpetrator is 16 and the victim is 13, then that is. But if they're 14, then it isn't. You know what I mean? So there's like, they said you're making it so fine-tuned that we're going to be forced to prosecute those cases, because parents are going to know those parameters and say, now you have to.
For it.
Yeah, and they said, let us just discern when it is and when it isn't.
Though the flip side of that is the fact that maybe it changes from district attorney to district attorney.
Right.
In terms of who's going to prosecute what.
Although we pretty much got unanimity on that. We didn't get any district attorneys that we found to be abusing that, you know. So sometimes we're better to leave the law where it is and then not toy with it a little bit. So there were certain people that were disappointed about certain issues that we couldn't cover.
Sure.
But we did try to do a lot on juvenile issues, on expungement, bail reform, tried to remove economic factors to pretrial detention, tried to allow
Let's
witnesses.
talk about that a little bit, the bail reform.
Right.
What came into play with that?
Well, essentially, if you're a juvenile now, they can't hold you in pretrial detention really because you can't afford bail. Because I think you and I will both know that there are people that are going to come in dressed nicely with their parents, and the parents are going to pay the bail, and then there are other people that unfortunately aren't going to have those resources.
Sure.
So we wanted to make sure, with the understanding that really no juveniles can really afford bail. So the bail is being paid by the parents, if anyone.
Right.
Yeah.
Right.
So we've tried to take that out, and only under circumstances of real necessity would a juvenile be held pretrial. We also will look in certain circumstances at, like the extreme circumstances, like if you are like a single parent, and like how much of an impact is that going to have if you're out of the house?
Sure.
You know, so what we've tried to do in the new bill is to really remove the economic factors and only place those on when it's appropriate or necessary. When there's really a flight risk or a danger to yourself or others that we you know, that is so extreme that they feel that you have to be held.
But affordability now becomes a consideration
Right.
that was to some extent a consideration, but was not a mandatory consideration.
And
at the time.
when you look at the constitutionality of that, you were only supposed to take as much as was necessary to guarantee their reappearance. And so how much is that amount? It varies depending on your financial status. You know, $5 to one could be $500 to another
Sure.
and $5,000 to another. So we really tried to change the bail statute, especially as it applies to juveniles, that you don't get held because you don't have the money for bail. And also look at that as in adults, like what is actually necessary to make sure you come back. You also had issues too with people that are, say, homeless. You know, people saying, well, how do we make sure they come back because we can't
go to their home to pick them up.
We can't go to their homes, yeah. So sometimes for people's own safety or health, and you try to get a speedy hearing or something, there's going to be situations where they're going to have to do that.
Sure.
But we're going to try as best we can. The new law provides a lot of options for the court, pre-trial.
Well, unfortunately, I think that that brings us to the end of our show. I think we can go on for fill a whole nother show with everything that's happened in the Criminal Justice Reform Act. And I thank you for coming on and talking with us about it.
Well, thank you for having me.
And thank you for your hard work on all of this.
Totally my pleasure. It was an honor to be part of it.
Well, I want to thank you all for your attention on this. And on behalf of Sheila Harrington, I'm Christopher Lilly. Good night.